documents around the founding and around the creation of the Constitution all reflect passionate belief in the importance of the jury, including the civil jury, which, as you may know from your experience in the trial court, is getting to be a rarer and rarer creature. And in fact, there are trial judges who have written about how do we keep the civil jury alive? And I'd like to hear your thoughts about whether there's more to the civil jury than just a fact-finding appendage of the trial judge, whether it was seen by the founders and whether it belongs in our constitutional structure as a part of the responsible self-governance that was established by our Constitution.
Yes, Senator. It is part of our ordered liberty. It is a mechanism by which citizens can participate in governance. They can be called upon by the court to sit in judgment of other people in the community. And it was something that was a part of the democratic vision of the founders from the very beginning.
Blackstone was one of the legal experts who the early lawyers of the United States relied on. I suppose there were lawyers who had nothing but Blackstone's commentaries and the Bible on their shelf. And Blackstone described the jury as having a role to make sure that the power and clout of big and powerful interests could be protected against, that it was a refuge from the power of what he called the more powerful and wealthy citizens. There was long experience in government of corruption, whether it was getting to a chief executive and getting them to do things your way for improper reasons, or whether it was controlling a legislature, a legislative body. But the jury is fundamentally different because they don't stick around. They're there for one case and one case only, and then they disappear. You can't fix them so that they decide your way over time. And if in that one case you try to fix them, you've likely committed a criminal offense. Tampering with the jury is a pretty significant thing, is it not?
It is.
If anybody tampered with a jury of yours, how would you respond?
Oh, very seriously.
So the jury lives in a protected environment from a lot of the political power and the danger of corruption that the elected branches often suffer. And do you have thoughts about the importance of the civil jury in that regard as the bastion where people can go, where they'll get a square deal from regular citizens and can stand toe-to-toe with the lawyers for however big or mighty an opponent they may have, with almost no danger, let's put it that way, little danger, less than danger, of the fix being put in?
Well, certainly the jury system is designed in that manner, that citizens are brought in from the community. When we pick juries, we ask as judges, do any of you in this pool have any connection to anyone? You know,
So you screen them for conflicts of interest?
You screen them heavily. That's part of the, what we call the voir dire, the sort of.
We don't do that with people who come to Congress.
Well, in the court
They come with their conflicts of interest, often right on their lapels, sometimes hidden in their back pockets. But juries, not so, correct?
Not so. And in fact, that would be a reason to exclude someone from the jury. And we even ask, you know, do any of you as judges, we say, do any of you know me? And if you do, you'll have to let me know and be removed. Because the idea, as you've indicated, is to get people from the community who have no connection to the case and can hear the evidence that's presented in the courtroom and the arguments of of the lawyers and make a decision that is unconnected to any sort of personal interest they might have.
Protecting the jury against the dangers of bias or corruption, giving the parties before it a clean and fair shot.
Yes, Senator.
So, with any luck, you will be on the Supreme Court before long, and I hope you will remember all of this, because it seems to me that the court has been on something of a campaign to deprecate and diminish the civil jury, including by allowing big corporations to build into their standard contracts, buried way down in the fine print that folks often don't read, and even if they do read it, they'll never get through the phone tree to find somebody to complain about it and try to strike it out of the contract. It's a take it or leave it adhesion proposition, and they build into that you've given up your right to a jury, your Seventh Amendment right to a civil jury. It's right actually in the Bill of Rights. And I cannot think of another right that the court pays less attention to or throws more readily under the bus. If you read the mandatory arbitration cases, there's rarely a mention of the Seventh Amendment. And it seems to me that it flies in the face of the purpose of the jury to allow the citizens of the greatest power and wealth, who are today corporate citizens, to actually be able to take on the ability on their own through contracts that the customer has no chance to negotiate. The employee has no chance to negotiate, to actually take away that right that was at the heart of our founding without a squeak of objection or even notice by the court. And I think it's created a dramatic shift in power towards big corporations. And I think it has harmed innumerable employees and customers. So I am extremely happy that you have been able to answer these questions with such clarity about the role and the history and the value of the civil jury and its importance, not just as your fact-finding adjunct, but as an important part of our constitutional structure, part of our structured liberty as Americans.